panel here today. Doug Archer is the Peace Studies and Global Affairs Librarian at Notre Dame. Bob Bosher, and Bob, I hope I'm not butchering your name, I apologize if I am, is a fellow in the ALA's Office for Information Technology Policy. Deborah Caldwell-Stone is the Deputy Director of the American Library Association's Office for Intellectual Freedom. Our moderator, Jamie LaRue, is the Director of the Office for Intellectual Freedom and the Freedom to Read Foundation. And Michael Robinson is the Chair of ALA's Intellectual Freedom Privacy Subcommittee and head of the Consortium Library at the University of Alaska at Anchorage. So with that, I'm going to turn things over to Jamie, and he's going to get us started. Jamie, welcome.
Okay, well, thank you so much. It's a pleasure to be here, everybody, and you are going to enjoy hearing from some of, I think, our sharpest minds in the library field about an issue that can be, on occasion, a little contentious. So with that, let's get started. The issue that brings us together here today, and this is always a wonderful way to begin, Bob will talk to us about the fact that there is new money on the table, and new money is a good thing. Next, we're going to kind of move to Doug, and he's going to touch base a little bit about ALA's history with filtering and kind of give you the high-level view of then and now. Then we're going to move over to Mike, who had by far the best picture of any of us on those introductory slides. So you can see him, his avatar, sitting there with a brew. He'll be talking about something that I suspect will be new to many of the people listening today, and that's a new cybersecurity issue that may reflect the way you think about filtering and how you implement it should you choose to do so. And then we'll go to our legal expert in-house, Deborah Caldwell-Stone, and she'll talk a little bit about the enforcement agency that looks after filtering in America's libraries. And I think we'll end up then with, I'll give the panelists a chance to ask some questions of each other and reflect on some of the things they've heard that they want to weigh in. And then we'll go back and take a look at your questions. So again, you heard a little bit of the introduction. Bob knows quite a bit about this technology. Doug is one of our most renowned commentators about all kinds of issues. Mike is our tech expert, Deb is our legal expert, and I'm along for the ride. So with that, Bob, I'll go ahead and, or Dan, I guess you'll hand over the ability to switch the slides there or turn on the sound for Bob, and I'll.
Yep, we'll pass things over to Bob. Welcome, okay, Bob.
Okay, folks, Dan, Jamie, thank you very much, and welcome to everyone out there for today's presentation. As Jamie mentioned, what I want to cover over the next few minutes as my part of the program this afternoon or today is some of the changes in the E-rate program and how these changes may impact what your library is thinking about in relationship to filtering or not filtering. And so I do also want to know that I worked for many years for the Wisconsin State Library and Education Department here in Madison, Wisconsin, still work out of Madison. I retired from full-time work a few years ago, but still work about a day or day and a half a week for the State Library Agency in Wisconsin, still providing E-rate and broadband support. So I keep my fingers, if you will, on the pulse of the E-rate program via that venue, and then also working, of course, as a fellow in the ALA Office for Information Technology Policy. So let's just quickly look from the 30,000-foot view in relationship to E-rate and filtering. My assumption is most people know this, so I'm going to go through this fairly quickly. The E-rate program, since its inception in 1996, it was part of the 1996 Major Telecommunications Reform Act passed by Congress. It provides discounts to schools and public libraries of 20 to 90%. That discount is based on poverty levels in your given community, and it's specifically measured by the number of students in the school district where your library is located that qualify for the federal free and reduced lunch program. So obviously the higher the level of poverty, the higher the discount that you're going to get. Nationwide, the average for both schools and libraries is about 60%. On these services that I noted just quickly below, the telecommunications services, so this would include primarily broadband. Historically, it has also included voice telephony, that is dial tone. We'll mention that in reference to some of the changes there in just a quick minute. It includes your basic internet access from your internet service provider. These are known as Category 1. And then it provides discounts on internal connections. So these are E-rate discounts on the networking hardware, if you will, inside the library building. So we're talking about routers and switches and hubs. And we're also talking about wiring as well. Now, the filtering mandate that applies to CIPA, and CIPA was passed about 15 years ago, and ALA launched a lawsuit against it, and Deborah will probably mention that as part of her program. It was found constitutional by the Supreme Court. It applies to internet access and internal connections. So if you apply for those two services to get E-rate funds, you do have to filter. And in a nutshell, and again, my assumption is Deborah is going to provide more information on this, you have to filter out obscene images, and nothing else has to be filtered. Now, there is an important exception to that filter, and if you get just telecommunications discounts through the E-rate program, for example, broadband connectivity, you do not have to filter. Now, as part of a major E-rate reform process, the FCC, starting in about 2013, started or initiated a major E-rate reform, and it was looking at the program from a comprehensive point of view. It was the most fundamental review and reform of the program since its inception in 1996. And the focus that the FCC has taken is to look at broadband connectivity and give that an emphasis or give that a primary goal. And when you think back when the E-rate program was created way back in 96, 97, very few libraries had internet access at that point in time, and those that did primarily had dial access through an old modem and the basic telephone line that some of us remember from those days. And of course, things have changed dramatically since that point in time. And we still have, from a library perspective, issues of libraries not having sufficient bandwidth. These two statistics that you see on the slide come from the ALA Public Library Surveys that the association does in coordination with the University of Maryland. And I'm sure many of you have probably filled out those surveys over the years. This is the latest one that shows 62% of the libraries had less than a 10 meg connection. And I should note that the FCC standard for just home access, not just library access, but home access is 25 megs. And then 41% of the libraries, regardless of what bandwidth they had, said their bandwidth was insufficient. One of the things that the FCC did, however, in order to free up some money in the program, is it did phase out, or is in the process of phasing out, discounts on that plain old telephone service that is the dial tone service. Another positive thing that the Commission did is increase the amount of funding from $2.4 billion to $3.9 billion annually. The good news is that this ensures that all applications are funded. In the past, because there was insufficient funding, that is the $2.4 billion did not cover all of the applications that were submitted, almost all internal connection requests were not funded. There simply was not enough money to go around. Now, in relationship to these E-rate reforms and filtering, yes, we lost the discounts on the voice telephony service, but we gained sufficient funding. And the result of that is that some libraries may be reconsidering their use of filters, or some libraries before, for example, when they would say, well, we aren't going to apply for internal connections because there's not enough money anyway. There is enough money now. So from a budgetary perspective, some of the libraries might be looking at filtering to say that, you know, overall we're going to gain, we're going to get more money out of this, and so we're going to, you know, kind of reconsider the filtering. Doug certainly is going to get into more details in relationship to the ALA position on that, so I'll let that go at this point in time. The Office for Information Technology Policy then has been working with the Schools and Libraries Division, the entity that administers the E-rate program, and the Federal Communications Commission, to look at the CIPA requirements, because for the most part, no one has paid much attention to these for probably the last 10 or 15 years. And one of the key aspects there is when you look at the law, it allows an adult to request of a library staff member that the filter be disabled for those libraries that do filter. So we were looking at ways in which to ease this process from both the patron point of view and the staff point of view. And one of those is cited in the July 24th Schools and Libraries Division news brief, where they confirmed that libraries that have patron authentication systems, which many libraries do at this point in time, can actually set up a process where the adult can check off on the screen, for instance, a little box that says, I'm an adult user and I want unfiltered access. So there's no direct interaction, if you will, between the patron and the librarian. We view this as a critical factor in being able to provide adults with unfiltered access so they can get information that they need that may be filtered out if that library uses filters. So again, I would encourage people to look at that. I provided that a link to that news brief, if you will, in the references at the end of these slides. So that's just my brief overview. I think at this point in time, Dan, I'll turn it back over to you, and you're going to turn it over to Doug.
All right, thanks, Bob. Doug, over to you.
Okay. All right, filters then and now. Well, then was very interesting. There was a lot of continuous discussion of filters and their effect on libraries. At the time of CIPA was passed, there were several attempts at federal legislation prior to CIPA. And the one thing I want to say fundamentally before we get any further is that the American Library Association, as I understand it, develops policy advising libraries as to best professional practices, offering their best counsel. It does not enforce anything. Every library is independent, and every library system to make its own decisions. So when we make a recommendation, it is a recommendation. So that will probably come up later when we talk about should or should not libraries be filtering. It's still and always has been a local decision. When filtering were first being used on the internet, ALA opposed their use because from every experience we had, I was involved in the intellectual freedom community at that time and have continued to be so. Filters overblocked constitutionally protected speech, and they underblocked the type of speech that they were trying to target. So this constant overblocking and underblocking seemed to make them particularly inappropriate for library internet access. ALA opposed to CIPA. We filed a facial challenge, that is, that CIPA was unconstitutional on its face because of the nature of the filters and how they would block out constitutionally protected speech. Supreme Court found otherwise. In particular, the fifth and deciding vote, Justice Kennedy, found that they were constitutional if unblocking was easily possible. We didn't feel it was at the time, and there have been cases in the past where it has not been easily unblocked. But that's one of the new developments recently, is the technology making it easier for unblocking to become a standard part of filter usage in libraries. CIPA only required the blocking of images plus a policy for internet use, and only if one wanted federal funds, which means many libraries chose not to ask for the funds. Now, that's one of the points of discussion right now. The fact that it only required the blocking of images made the discussion very complicated and very interesting, in that it's one thing to have a filter block language or to block specific sites or IP addresses. It's a very different thing to ask a computer program to block an image. There have been a lot of attempts, and as far as we can tell, with the latest research, there were none that could do it well when CIPA was passed, and there are still none that can do it well. So let me go to the next slide here. In 2014, ALA's OITP and the Office for Intellectual Freedom released a study done by Kristen Batch entitled Fencing Out Knowledge, in which significant research was done on the effectiveness of filters in libraries. And we found that filters continue to over and underblock. And therefore, the association cannot recommend filters. And that's the language in the interpretation of the Library Bill of Rights on filters that was passed at conference a year or so ago. Now, I need to be very clear that we chose that word extremely carefully. We're not condemning libraries that choose to filter. We want to recognize that we can't recommend them, but that does not mean that a library that chooses to use filters is somehow evil. That has been communicated at times in the press, and it's simply not true. We understand that all decisions are local, and people have to make their own decisions. We want to continue to support all of those libraries that have chosen not to filter, but also understand that some will feel that for whatever reason, particularly local considerations, local politics, various factors, and monetary considerations, in order to have any access at all to the internet, libraries may choose to use filters. The question then becomes, how do they use them most effectively? Well, minimize the negatives. If you choose to use filters, then try to minimize the impact by selecting the flexible filter possible in your budget area. Filters vary widely in what categories of speech are filtered or not filter blocked, and at what level they can be blocked. Remembering that CIPA only requires that you block images, and we know that you can't do that anyway, so you set the filter at its absolute minimum and get a filter that provides for the minimum filtering, and you're much closer to having open access. And maintain as much local control as possible. For instance, some libraries are in larger systems, and the question about unblocking for an adult requesting access becomes a problem if it has to go through the local city council, city operation, or the local school system, or whatever cooperative venture one is connected to. So if you can maintain local control so that it's your choice, that maximizes the positives, minimizes those negatives. And when you choose a filter, and it does have options, it will likely come with certain default settings, often set higher than you can possibly need to apply to qualify for CIPA. So you get the filter, you set the settings as low as possible, filter the minimal amount of information. That is, block as little as possible, consistent with CIPA. And CIPA only requires blocking images, which you can't do anyway, but you can at least try and use the lowest possible setting in that filter that would be appropriate. It's very tempting when a vendor provides you with a filter system that blocks all types of offensive speech, if you choose to do it, to say, well, this particular type of speech might be particularly offensive in my community. Why don't we set that filter on? That would be directly opposite of our basic policy. You do not want to be setting filters to be to address questions of offensive content. That's an open door to all types of difficulties, because which do you filter and which not? It can be everything from hate speech to different points of view on political issues to sexual materials that are not under the definition of CIPA. It's just an easy thing to do, but very dangerous thing to do. So simply put the settings at their lowest possible level, and you'll be in about the best situation as you can be in. That, I believe, concludes everything I need to say at this point. So I'll pass it on.
Okay. Thank you, Doug. Appreciate that. Mike.
Okay, good morning. I want to thank Dan for the introduction. He promoted me to head of the library, and just in case my dean's listening, I wanted to point out that I'm head of the systems department. Even though I am working at an academic library, I do have past experience working in a public library, and I have worked with filters before. What I'm going to talk about is, Doug told us how to minimize the negative impacts of filters, and I'm going to talk about HTTPS and the effect of filters on HTTPS and vice versa, and how that might be a negative impact on your patrons' privacy. So I'm going to go over, there's going to be some slides. Hopefully we can explain some of the pieces that work and what the implications are. So in general, this diagram hopefully shows kind of how traffic works when you're not filtered. Your browser talks to a website, and the communication goes back and forth. This is pretty simple, but I just want to kind of lay out the basics here. When it's filtered, your browser, all your traffic between your browser and a website goes through a filter, and that filter can be monitored and recorded, and all the transactions can be recorded and seen. The way filters, and talked about this, Doug talked about this a little bit, the way filters work are kind of in a couple of broad categories. They can block based on the domain name, playboy.com, or a particular part of the URL, perhaps the name of the file or the folder it lives in. And they can do this by creating either a blacklist of sites that are blocked or a whitelist that sites are allowed, or some combination of the two. Filters can also block on entire protocols or ports. So you can block all of FTP, all video streaming, all proxies, things like that. Now, I'm just explaining how filtering works. I'm not suggesting anyone does any of these things. I'm just saying that these are the capacities most filters have. And the third area they block in is they actually inspect the content of a web page to allow or deny the block. So that gives the filter more sophisticated techniques to try to block things. You can look for keywords inside a web page. You can look for types of embedded content inside a web page. Most web pages are made of multiple sources of content nowadays. And metadata around images. So when they are trying to block just images, they're trying to figure out things that describe that image in order to know whether to block it or not. Now, what HTTPS does is it encrypts the communication between the browser and the website, as most of us know. The contents of the web page is encrypted. That means that you can't see that if you're not either on the browser or on the website. The domain name itself, playboy.com, is unencrypted, but any particular subdirectories beyond that would be encrypted, and so you can't see that. What this means for filtering is that, in essence, encryption breaks the filter, at least part of the filter. The filter cannot inspect the contents inside the pages themselves or the rest of the URL past the .com. So if we look at how filters, content filters work, the strike-throughs here represent what the filter can't do anymore when HTTPS is turned on or is in play with websites. However, vendors are pretty clever, and they've come up with something for filters called, it's called various things. Sometimes it's called HTTPS decryption, SSL decryption. It's a setting that can be turned on in the filter. And what it does is it allows, if the bottom part of this image shows, is it allows the filter to intercept the encrypted communication. And basically, the browser talks to the filter talks to the website and back. And it does it by inserting itself in the middle of this secure communication. So the filter does this by presenting certificates where it basically pretends to be the requested HTTPS site. That's technically what's going on. Now everything that's HTTPS, all those web pages can now be monitor logged and inspected. This would include financial, commercial, legal, medical, educational, usernames and passwords, account numbers, and PII. Sometimes this is referred to, this technique of SSL decryption is referred to as a man-in-the-middle attack because it's used by hackers and other people to trick people into thinking they're having secure communication with the website when they're really not. But that's not the intent here, but you will hear that term used, man-in-the-middle attack. PII is other personally identifiable information. So this has a lot of implications for privacy in libraries that need to filter or choose to filter for whatever reasons, whether it's for CIPA or local community pressures or it's being imposed from the outside. Basically, a recent study showed that 50% of the web is now encrypted, HTTPS, and more of it's moving to that. And this presents a challenge for content filtering. HTTPS breaks filtering So if you don't turn on SSL decryption, all you can filter on is the domain name, you know, playboy.com, google.com, whatever. But if you turn on the decryption, it really compromises privacy and security. And it puts libraries that do need to filter kind of in a bad a damned if you do, damned if you don't situation. Is filtering only on the domain name good enough? Does it provide enough options? A lot of IT folks want to scan for malware and other threats, you know, and if you don't turn on decryption, they're not able to do that. If you do enable decryption, you at minimal would need to notify users that you're decrypting their supposedly secure web transactions. So what would that notification look like? So that's kind of what I had to offer, and I will hand it now over to Deborah.
Okay, and actually, Deborah, before you start there, I just want to jump in and say this is something that I really want people to hear. As we've talked in the past about the big push to move to encryption of the web, the point to that is to preserve privacy. And we really haven't talked before about this new issue related to filtering, which is that if it interrupts that secure connection, we are also violating the security of our network and the privacy of our patrons. So really wanted to underscore that, and thank you so much for that. Deborah, take it away.
Thanks very much, Jamie and Michael. I'm going to very briefly get into the requirements. Both Bob and Doug have alluded to this earlier in the discussion, but I'd like to talk about what the actual requirements of the law are. The basic requirement is the adoption of an internet access policy that requires the use of what the law calls a technology protection measure. And usually this is filtering software that prevents access to certain categories of images that are published on the internet. The filtering software must be set to prevent adult users from accessing visual images that are obscene or child pornography. And both of these terms have a very specific definition in the law. The courts have outlined what it means to be obscene, what it means to be child pornography. And for minor users, the filtering software must be set to block access to images that are considered harmful to minors, in addition to blocking images that are deemed obscene or child pornography. Now, harmful to minor images are sexually explicit images that adults actually have a legal right to view, but are deemed to lack any serious literary, artistic, political, or scientific value for minors, and thus it's permissible to block their access to those images. Now, in addition, the Internet Access Policy must include provisions that allow adult users, those 17 or older. Remember that under CIPA, a minor is anyone under 17, and 17-year-olds are treated as adults. But anyone as 17 or older can ask a librarian to unblock a website or disable a filter to enable access for research or any other lawful purpose, which includes accessing their email or even just doing unfiltered web browsing. As the Supreme Court has interpreted this, as the government itself offered at oral argument during the Supreme Court case, no questions need to be asked of the library user. They can simply ask for the filter to be unblocked or disabled, and the library should have a procedure in place to do that as quickly as possible. Finally, schools and libraries subject to CIPA must affirm in writing that they are using filtering software on all their computers owned by the library or school. That's it. That's really all that's required. CIPA does not require schools or libraries to do any additional filtering. It means that they don't have to block access to any text-based materials, period. It's not required by the law. They don't have to block access to websites that contain controversial content, controversial opinions. Most often we see this in context dealing with LGBT concerns or alternative religions, but there's no requirement to block this because none of this falls under the categories of illegal images that are blocked under CIPA. Doesn't require the blocking of social media sites or search tools. In fact, guidance has come from the FCC specifically stating that neither Facebook nor Twitter or any social media tools should be regarded as automatically harmful to minors and therefore blocked with filters. And finally, there's no requirement that you track or monitor web surfing habits of your users. In fact, there's a specific provision in the law that bars the use of filters or any technology to track individual users' use of the internet. And you have to understand that the FCC is actually quite liberal about this, about enforcing the law. Now, we should talk about a little bit about this idea of obscenity, pornography, harmful to minors. The first thing you have to remember is that pornography has no legal definition. The law doesn't recognize the term and doesn't use the term. When courts discuss illegal content, they discuss obscenity, child pornography, and harmful to minors. And these terms have a very are defined in the law with very specific terms. Prurient, sexually explicit content that seems to have no redeeming value either as literary works, artistic works, scientific works, or political opinion. Child pornography, of course, are actual images of children being forced to engage in sex acts. And we talked a little bit earlier about what harmful to minors is. That is, these are sexually explicit images that are legal for adults to view and access, whether in print or on the internet, but we've deemed them to be obscene for minors because we don't believe they have that redeeming value for minors at all. Now, the Federal Communications Commission is the agency that's responsible for enforcing CIPA and promulgating rules for the use of CIPA. And as I mentioned before, the FCC is very liberal about this kind of enforcement. The regulations governing CIPA give both libraries and schools considerable latitude on how to implement CIPA. In fact, the agency has specifically refused to establish criteria for what constitute effective filtering, has refused to endorse any filtering software, or to adopt any rules that enforce a particular standard for filtering. And even when a school or library is not in compliance with CIPA, the sole penalty is a requirement that the school or library refund any monies received under CIPA for that period of time when the school or library didn't meet the requirements of the law. And to date, we're unaware of any instance when the FCC has found a school or library to be out of compliance with CIPA based on its filtering practices. What the FCC has actually said is that they've provided the maximum flexibility possible by crafting the minimal amount of rules around filtering. They want to give libraries, they want to give schools the ability to come up with solutions that suit their local communities and that suit the needs of the library and its users. This flexibility is an opportunity for libraries who need to filter under CIPA but want to try innovative methods of complying with CIPA's requirements in order to provide users with the greatest possible access to online information. For example, when CIPA was first implemented about a decade ago, one West Coast library came up with a really creative solution. They simply adjusted their browsers so that all images were blocked. That complied with the law. That's all they needed to do because that was the minimum, that's what the law required. Of course, that solution doesn't work well in our very visual and interactive internet these days, but it's an example of how libraries can start thinking about and crafting new ways of complying with the law while still trying to maximize access, trying to comply with values of intellectual freedom and support the First Amendment. One thing, and Bob mentioned this before, libraries can experiment with how they provide the ability to unblock or disable the filter. Using library card numbers in a technology system that we've verified the age of the user so that they are able to input their card number and immediately unblock or disable the filter without the involvement of a librarian. Mike has brought up a very important issue about encryption. And if the library wants to address this issue of protecting the privacy of library users, you know, the flexibility provided by the FCC allows libraries to experiment and develop new methods of filtering that don't decrypt encrypted communications, that allow the library to assure their users that when they use library computers to access their financial records or communicate through encryption with their medical provider or access sensitive information, that in fact is remaining an encrypted communication. While more specific rules might offer reassurance to some schools and libraries who are concerned about complying with the law, such rulemaking might actually limit the ability of libraries to craft these creative solutions. We want to encourage libraries that are required to comply with CIPA to use this flexibility to develop new means of complying with the law that are respectful of intellectual freedom rights, respectful of privacy, that represent First Amendment friendly filtering. I'll pass it now to Jamie.
Okay, thank you so much, Deborah. Let me see if I can get my slide to advance here. So I guess the first thing that I want to do is first kind of set a very broad kind of comment here, and that's that everybody is aware that when the internet came to the universe of libraries, we let a lot of new content into our systems and to available to public access. And that was a sea change for libraries. And so as we tried to grapple with various ways to manage the behavior, I think that the fundamental difficulty is we're balancing the value of we supervise public space, whether it's school or public or academic library, and we are primarily First Amendment advocates. Our role in society is to provide access to content. And so what you've just heard is that the only guiding law that we have here, the only things that have been determined to be illegal, as we've heard from at least 3 of our panelists, very specific decisions in the CIPA case. Only 3 kinds of pornography are illegal. And we've also heard something new that, as Mike has pointed out, that we haven't heard a lot about filters in a while because libraries are out there trying to apply this in ways that make sense, and we step in as librarians when it looks like somebody is misbehaving. It's not a technical problem, it's a human problem. So I wondered if just now that everybody's had a chance to kind of listen to each other, one more round of our panelists. Bob, do you have anything that you wanted to comment on that other panelists said that you thought needed some amplification or response?
Just a couple of things, Jamie, one of which is to emphasize what Deborah said. I was on the ALA E-rate task force back in the spring of 2001 when the FCC crafted its CIPA rules. And we on the task force had many conference calls, probably weekly conference calls for about a 2 or 3 month period. And it was obvious at that point in time that the FCC was doing whatever it could within the context of the law to give libraries the maximum amount of flexibility in how it interpreted their need, if you will, to comply with CIPA, and Deborah brought that out in relationship to her comments. Also, I see in the chat line here a couple of people have commented about wireless access. I think it's quite clear, and we've gotten informal information from the FCC that this is correct, that patron devices, a laptop, a tablet, whatever the patron may have that connects to the library's Wi-Fi network does not have to be filtered. Because when you look at CIPA, there's a couple of sections there that refers to its computers, and that pronoun clearly means the library's computers in the context of the law itself. Now that being said, depending on how your filter works in your networking environment, that device that the patron brings in may be filtered anyway because your filtering is happening higher up in the network. But again, ALA feels very strongly that patron-owned devices do not, under CIPA, have to be filtered. Back over to you, Jamie.
Okay, excellent. So Doug, any comments again as you've heard some of the other panelists' comments, anything that you want to amplify on?
Oh, I was just typing.
Well, that's good. You're conversing with two sides of the brain.
Yes, there we go. Two things at the same time. I think I'm particularly concerned to be clear that since CIPA, I was just responding to the person that asked about as applied challenges. I'm not aware of many. There have been controversies in local libraries, and only one case that I know that got into the courts, and that was in Washington State, and there was a very ambiguous decision. Deborah
Doug?
can speak to that. Yes.
Yes, Doug, I was going to address that in my remarks.
Oh, excellent.
So why don't
Great.
you go ahead, all right?
Well, I'm just saying it was a very ambiguous situation, and there were questions about was the ability to unblock, how was that applied? Were the sites actually completely blocked? I don't remember the details of it now, except that the court decision was so ambiguous that it wasn't even published, that it doesn't provide a precedent for anybody else. So as far as I know, there have been very, very few actual court challenges as applied. There's certainly been local arguments and discussions, but that's as far as I know.
Okay, I think what I'd like to do is let's jump over to Deborah to speak to you specifically about some of the court cases, and then Mike, I'll come back to you.
Yeah, in fact, there have been a number of court cases challenging local filtering practices since CIPA was implemented. Most famously, a number of schools and libraries that were filtering in such a fashion that it blocked pro-GLBT content. Specifically, they targeted websites like Parents and Friends of Gays and Lesbians, the Lambda Legal Defense Fund, sites that essentially promoted same-sex marriage, promoted the right, civil rights for GLBT folks, were blocked in those schools and those libraries. While the filters allowed access to ex-gay ministries and reparative therative sites that encouraged people to change their sexual identity. And what the courts found in these cases, that was viewpoint discrimination and a violation of the First Amendment right of the library user. And in some of the cases, the library actually had to pay attorney's fees to the ACLU who had sued on behalf of the library patron. In another case, where a patron sued a library, the filter out of the box had been set to block access to what was called, quote, alternative religions, which means that it was blocking access to Wicca sites, pagan sites, I believe even some Islamic sites. And when patron asked to access those sites, the library denied access to those websites, even though they had, did not fall under the definition of a visual image that was obscene or child pornography or at all. And as a result, the ACLU sued on behalf of that patron, and that case settled, and the library agreed to supervision of its filtering practices as part of its settlement. So there is a vulnerability to lawsuit if you are engaged in overfiltering, if you're not thoughtful about what categories of speech you're blocking. All that CIPA requires is the blocking of content that's already illegal under the First Amendment. That is obscenity, child pornography, and in the case of minors, that obscene for minors content that actually is legal for adults to view. You do have to be thoughtful about not how you filter. And given the fact that overfiltering has actually been a source of liability for libraries, thinking about filtering to the minimal requirements of law is actually the safer thing to do.
Okay, Mike, back to you. Any comments as you've listened to some of this discussion?
No, I would reemphasize that the HTTPS, that if you do turn that on, a lot of your IT folks will want that turned on to make your filter smarter. And the implications on security is just huge. I mean, it allows you to see people's banking transactions and various other things. So I just think it's going to be a growing problem.
You know, and I think one thing I'll toss on there as well about some of the comments I've heard about filtering companies, and this is something that always worried me, as public entities, as charged with providing access to information, we don't know what blacklists or algorithms are being used by most of the filtering companies. And there is a lack of transparency in that bothers me a great deal. So we don't know ultimately who the owner of some of these companies might even be, or what hidden biases might exist in the filters. And I think that's something that is difficult to support as information First Amendment professionals. Okay.
And what if your filter gets hacked? What if your logs of all those transactions get stolen?
Well, that's a good
You've now put the library in a position of being a trust keeper for all this secure information. So.
Yeah, so I think the idea about the man-in-the-middle attack, the ability for the filter to interrupt an previously encrypted connection, means you're exposing that liability of the patrons and the banking transactions that go on there, and other kind of protected expectations that patrons have about their use of the library. So I think that going forward, as the ALA starts to take another look at what it recommends, the idea about using man-in-the-middle filtering, which is that keyword blocking and trying to filter down within the domains, is a new thing to warn our members about.
Yeah. Now ask yourself, would you use a computer on a network that said, we're going to watch all your encrypted activity, but don't worry, nothing bad will happen. So.
Yeah, and I see here Tom Ayers just put something about intentional backdoors in the filters. As I say, if I were a government spy agency, I would get in the filtering business, because then I wouldn't even have to do warrants. I would just have access to the information by running the filter.
Or if I was a filtering company, maybe I want to have usage data to improve the product.
Another. Okay, so I'll go back to all of us here, including Dan. Are there questions that I kind of pushed to the end here that we haven't gotten around to yet?
Yeah, and we've had quite a few questions, so I am doing the best here to keep up, and I know some of them were answered in chat. So I'm trying to work backwards here. Let's see. Can we discuss what libraries do to protect themselves from situations such as the one that unfolded at the Orland Park Public Library?
Yeah, I'm sorry, someone else about to speak up on that one?
I'll let you take the lead on that one, Jamie, but okay. I'll add to it as necessary.
Okay, so here's what I believe. I think that there are at least 3 elements of this one. First, a library has to follow the law. It has to understand the law. And for those of you who have said it on today's webinar, you now have a much clearer understanding about what CIPA actually requires. So if you accept that federal money, you need to have a software protection measure in place, typically referred to as filtering. The second aspect of this is a policy about what acceptable internet use might be. And I think typically best practices, you talk about that with your community, you have a chance for people to comment on it, and although you'll probably not find an absolute agreement in the community about what constitutes acceptable, you can work out some sort of set of rules. And then I think the third piece of this about policies happens to do with patron behavior. And as I mentioned, any library worth its salt, whether you have filtering or not, wanders around the library and kind of monitors patron behavior. Somebody's typing really loud there. I don't know. Could you mute yourself if you're one of our panelists? So the idea about having an acceptable use policy, what is appropriate behavior, is something that librarians have always been trying to take care of as long as there have been libraries. And then the last thing is that, so what happens if you have somebody who comes in and, as I would argue is the case in Orland Park, and begins to make a very large deal about some perceived difficulty? my first notion is a library should always accept, listen to, respond positively and courteously to patron complaints. They should investigate those complaints. But recognize that sometimes even if you've done that, or if you don't do it well, things can blow up on you. So once again, those of us in the public world understand that you do your best to understand the law, you do your best to monitor public space, you try to make sure that you are welcoming and courteous, and even then sometimes things will go wrong.
Jamie, this is Bob. I've got just a couple of quick comments here.
Sure.
Okay, one of which is, last time I heard about 48 states had laws protecting patron privacy. I know in Wisconsin we have an Attorney General's opinion that that included protecting privacy of online information. My assumption is most of the state statutes could be similarly interpreted, but folks at the state library level may want to check on that in their respective states. Another comment we had was from a school person, even though this is a program targeted at public libraries. The vast majority of complaints that I get with my work that I'm still doing here in Wisconsin is from school people, teachers primarily, who say that the school network is locked down so tight that is really blocking access to a lot of sites that students, should be able to get to and can't. And that's a real problem because schools oftentimes like to play it safe, and the safest way to do that is to lock everything down. Oftentimes this takes a decision at the principal or even superintendent's level to get the technician to open things up to allow that access by the students and the teachers in the school environment.
Really excellent point, Bob, and I would say that most of the cases that we receive at the OIF about reported overblocking are coming from schools for exactly that reason. It isn't the librarian that chooses the filtering software, it's the IT department. Their concern is they're flipping every one of those switches that Doug talked about, so it's hate speech and bullying and alternative lifestyles, and by the time that it's done, you can't even gain access to the databases that you've subscribed to because the filtering is stopping them. And so I think one of the things we talked about with Mike is to say it may be necessary for us to put together a kind of a toolkit to say that if you decide to install filtering, have some talking points to begin with the superintendent and the principal and the tech people to say, we don't have to hit all these things, we shouldn't hit all of these things, and here's why.
Yes. And it should be noted, too, that the FCC and the Department of Education have issued specific guidance to schools that are filtering that, that social media, YouTube, similar platforms should not be arbitrarily blocked out of fear that there might be some content on those platforms that might fall under the definition of the images that need to be blocked under the law, that rather they should be presumed to be legal, accessible content and allow access to those platforms for students. And some of this is very practical because students need to learn how to navigate the internet. It's part of a digital literacy curriculum to allow them to be guided on the use of these platforms and what to do when they and how to interact on the internet in a safe way, and so that they're prepared to be great digital citizens when they leave school.
Okay, Dan, have you picked up any other questions here that I've missed?
Yeah, we've got
plenty.
Yeah, so I apologize in advance that we're not going to get to all of these. Someone asked a really good question here that's a little more of like how to deal with things on a personal level. Someone said, they're asking specifically about high school librarians, but I think this could apply to almost anyone. They said, how do I as a high school librarian convince our tech department, which is fixated on a lockdown mentality, to help to start loosening up a little bit?
Bob, I'm going to toss one back to you. Know of any successful approaches for that? I can tell you're thinking. Okay, so Carolyn put out a comment here to say that a suggestion for school districts to form a filtering committee. I don't know about that. I think that much smarter, I believe, to put up an idea in the beginning to say we're going to discuss this, we're going to build some general principles, and recognize that the marketplace of filtering is a competition on the basis of features. And we can say we are not going to go in and flip every one of these switches because we think it creates a barrier to student research and the development of critical thinking. But I think approaching it from a policy standpoint, getting it up to board level discussion might be a way to jumpstart that or jump over the technician that imposed greater filtering than you needed. I wanted to go back to one of the comments that Paul had asked. I know he asked this a couple times, and I don't think I know the answer to it. And it says, can we pick up on the adult asking for disabling on behalf of a minor? You know, so what the law says, I believe, and Deborah, correct me if I'm wrong, is it says adults have the right to request lack of filtering or to turn off the filtering. I don't think it addresses whether you can turn off the filtering for that adult's child.
That's correct. The law does not have any provision for disabling the filter at the request of a minor, and doesn't allow a proxy to request that unblocking for the child. So as a result, for example, in children's rooms where the children are using it, you really just can't unblock the filter even if the parent is requesting it at that time. I suppose you can't do much if a parent requests disabling for his own computer or her own computer and allows the child to sit with him or her. One thing I will note, though, and which needs to be mentioned here, is that when the filter wrongfully blocks a perfectly acceptable site, let's say CNN or Time Magazine, something like that, it's not against the law for the library to correct the mistake for users of all ages, to unblock that legal site for any user, so that you're not arbitrarily denying young people access to internet sites that they have a right to view, frankly, because they're constitutionally protected for minors and adults. So that should be probably something that every library should consider incorporating into their policies and procedures.
Good suggestion. Okay, Dan, I see we're coming close to the time to wrap up.
Yeah, we are just about at the end. No, I just wanted to ask, well, to thank everybody, to thank our audience and our panelists, and Jamie and the panel. I wanted to ask if anyone had any closing thoughts.
Just make one comment about the local cases. I kind of missed something there.
Go ahead, Doug.
I was concerned about there have been no cases that have gone to the appeals level and established precedent. There have been plenty of local cases, and most of those cases, as far as I know, have been settled in favor of the patron.
Yes, that's correct, Doug. And you know, usually what's happened is that the level of censorship is so obvious that the
yes.
local entity chooses not to appeal the decision in favor of the patron.
There you go. Thank you.
Okay, and I wanted to extend my thanks to Dan Freeman for hosting all this and all of our astute panelists, and end with the plug, which is to remind everybody that Banned Books Week, which is the American Library Association's focus on celebrating your right to read, which this year is from September 25th through October 1st, is coming up, and we hope that you will be participating in activities regarding that event.
All right, thanks, Jamie. Thanks, Mike, Deborah, Doug, and Bob. And you guys have been a great panel today. Our audience has been wonderful. We will be sending out an email giving you access to the archive. Please join us next month. We're going to be talking about diversity in libraries. I hope everyone has a wonderful day, and I hope you got a lot out of this presentation. Thanks.